Hi, I'm David Chaplin from IR35 Shield, and this is our first video podcast. This week, I caught up with tax barrister Keith Gordon from Temple Tax Chambers, and we discussed various case law factors surrounding the presenter cases and IR35 matters in general. We focused a lot on the Kickabout case, which is at Upper Tribunal this week, and we've explored the areas of potential contention in that case and looked at what we think might be the key areas to look out for. We hope you enjoy the podcast and we hope you find it useful and both entertaining. Hi, I'm Dave Chaplin, the CEO of IR35 Shield and Contractor Calculator and the author of a book on IR35 called IR35 and Off Payroll Explained.
Hello, and I'm Keith Gordon. I'm a tax barrister practicing from Temple Tax Chambers. I mainly advise taxpayers in disputes with HMRC and whenever I can, try to avoid taxpayers from having disputes with HMRC.
Keith kindly approached me this week with the idea of creating a video podcast on the topic of IR35 in the lead up to an Upper Tribunal case for a case called Kickabout that is going to be in the courts this week. So to put this into context, for many years, I guess since April 2000, HMRC have been chasing contractors, particularly in IT and engineering, and trying to sort of say that they're deemed employees under the intermediaries legislation. But in more recent years, we've seen them turn their attention to the media sector, in particular broadcasters, and we've seen a number of cases go through the courts, and that they are now about to challenge a decision. I say they, that's HMRC, where they lost a case against Paul Hawksby, who's on Talk Radio. Keith, before we get into details of the case, could you perhaps explain a bit about what's happening at Upper Tribunal rather than sort of first tier?
Yes, absolutely. When you have a dispute with HMRC, the first port of call, if you're going to the courts and tribunals, is the first tier tribunal. And that's where you have the full-blown argument, you have all your witnesses, you get to hear what the facts are and arguments as to what the facts are, and you also get arguments as to the law. Whenever a party is unhappy with the decision of the first-tier tribunal, then that party has the right to appeal to the Upper Tribunal. Now, the Upper Tribunal is equivalent to the High Court and often has a High Court judge hearing the case. But it is different because the High Court judge or the Upper Tribunal will not actually hear any fresh evidence. They will make a decision based upon the facts already found in the first tier below. So it's effectively an argument as to the law. Did the first tier make a correct decision on the law based upon the facts as found by the first tier?
So I guess if at first tier you haven't presented all of your facts, it's sort of, you had your chance, mate, and that's it really. You can't put anything back on the table.
Absolutely, there are always exceptions to the rule, but the facts found by the first tier tribunal are more or less final, and you very, very, very rarely have a chance to introduce new facts further on. So
could you just set the scene for us about this particular case? It's called Kickabout. It's about an appellant, Paul Hawksby. He's on Talk Radio. He's been presenting something to do with football. Neither of us really know much about about football. And he won his case at first tier, and then HMRC decided to challenge that and go to upper tier, and that's what's happening this week. What's this case all about?
Well, ultimately the question is whether or not Paul Hawksby, who provides his services through a company called Kickabout Productions Limited, whether he ought to be taxed as if he were an employee of Talk Sport, the radio company that is actually broadcasting his show. And he's one of two presenters on the show. And the whole thing about IR35 is whether or not you are like an employee, but because of the company between you and your client, you are not an employee, because the revenue want you to pay tax as if you were an employee. So the question is, look at the relationship between the presenter, Mr. Hawksby, and Talk Sport Radio, and does it look like an employment contract? And that's a question of law, which the first tier tribunal has made one decision on. In fact, it was a tied decision. in that the judge and the member sitting with the judge disagreed on the overall answer and a couple of steps in reaching that overall answer. But nevertheless, the judge has a casting vote, so the decision of the tribunal is the decision of the judge, which went in favour of the taxpayer.
And is that quite unusual for the two judges? I say two judges, it's one judge, isn't it? And then another person that sits with them.
Yes.
Is it quite unusual for them to disagree?
It's very rare. The very first time I believe it ever happened was in the case of Jones and Garnett, which is almost one of the first such cases. It wasn't quite on IR35, but it was another contractor. And that was the first time that there was a tie, and it's happened possibly once every 2 years since. It's becoming more and more common. But that's just a sort of almost a curiosity. It doesn't really affect how the upper tribunal is going to decide the case this week.
Okay, so if these judges can't even make up these decisions, can't decide themselves in court, and they've had all of this experience, how on earth are taxpayers supposed to work out their tax position?
Well, I think it's absolutely impossible. In fact, if we look at one recent case, an HMRC officer said under oath that it takes about 3 years to be trained up to deal with IR35, about 5 years to become expert. I can't remember.
I remember that, yeah. I think it was the payer case, that one.
It was, and this is something which is, it's almost impossible for anyone to have any real certainty as to what the ultimate situation is like. And this is one of the worrying things about IR35 generally, because IR35 is being, the terms are being changed with effect from next April, and they're already changed for the public sector. And the Revenue has put out a computer program, which you're very familiar with, called CEST, which is telling you how the Revenue views your contract. But the CEST program is so widely accepted to be flawed, it's really not worth following, unless you can get a positive decision in your favour, which the Revenue will abide by, provided they accept that you've entered the answers correctly. But it is so skewed in favour of the Revenue, it's not a particularly reliable guide, and the Revenue is using certain case law which supports their arguments, but not necessarily the case law which goes against their views.
The classic cherry picking and selectively choosing the evidence to support your arguments.
Well, it certainly looks like that way. They might explain it a different way, but it certainly looks as if they haven't actually followed all the law. And in fact, I think it's fairly clear they haven't accepted all the law, because they say the question of mutuality obligations is not something they factored in. But the case law seems to suggest it is a very relevant factor.
I actually remember asking you the other day, I think it was on a webinar that you were on.
Yes.
And I asked that after the professional referees case, which was heavily around mutuality of obligation, was at the upper tier, I asked you, should HMRC finally sort of selectively throw in the towel and update their CEST tool to properly adhere to mutuality of obligation? And you said the short answer is yes, and the long answer is yes, definitely, which I thought was brilliant.
Absolutely. I think CEST or any replacement would be a lot more accepted widely if it's not just the Revenue programming the questions and they actually put it out to a wider panel, so that there could be a general consensus that this is as best as you can get. But when the Revenue select their own questions based upon their own selection of case law, it undermines the credibility of this tool, which they then present to Parliament as their way of helping taxpayers cope through, find their way through the legislation.
Yes, I mean, we find ourselves talking about CEST, which wasn't actually what we were planning on chatting about. And I could talk about this forever.
But whenever we get so late and talking about IR35, I guess CEST does rear its ugly head.
Yeah, we did have a conversation about trying to get the Lorraine Kelly case through there, and neither of us could manage it. And it's unfortunate. If they actually came out with the tool and it gave the right answers, I'd be quite happy to say so publicly. It makes no difference to me whatsoever. It bothers me, as you know, that they're effectively trying to override the law by the back door. And the law is what the law says and what the courts say, not what they just decide to put in their guidance. Going back to the Kickabout case,
Yes.
how does this case compare to, for example, the Payer case? That's the one with the BBC presenters. Then there's the Albertel case. That's the Lorraine Kelly case. And then the Ackroyd as well, I guess. And then also Atoll Productions. There's all these presenter cases.
Yes.
And they all seem the same but different. It's just, I know that sounds weird, but.
No, well, as the judges will always say, each case has to be determined on its own facts. And clearly, the picture you're going to draw is going to differ from all facts, from different cases. But interestingly, the contracts in these cases tend to be pretty similar. I would say that the Krista Ackroyd contract in her case was markedly different, albeit only in subtle ways. But these contracts almost seem to be industry standard. And that in itself gives rise to a question relevant for IR35, because it's not so much the question as to what is the contract under which you're operating, but it's what would the contract be if you had contracted directly between you and the broadcaster. So there are interesting questions there. But even if we assume that the contracts are more or less identical, and those are the ones which the courts would have to consider for the IR35 test, because it looks at a hypothetical contract. Even if you assume that these are pretty similar, I think one can distinguish between the Payer and the Krista Ackroyd cases from the other cases. Krista Ackroyd and the Payer case both involve people working in the news team, and there are a lot more restrictions applying to people working in the news output. So if there is going to be a boundary between some presenters and other presenters, then I would say that the line is drawn through at the Krista Ackroyd, the Payer case. I'm not saying those were decided, but I'm sort of think that they will have a harder job in persuading a court or tribunal they're not employees.
Yeah, this is getting around this whole contentious area of control, isn't it? And what's produced, the output. So in the Kickabout case, he sort of broke that down into, well, what preparations are done to them before you then produce the outputs, and then having produced the output, whilst you're producing the output, are you controlled a bit whilst you're doing that? And then once it's been produced and it's made, control over that output, does that necessarily mean it's control over you? And it seemed that in the Payer case, those nuances weren't necessarily teased out, but they were in the Kickabout case.
Yes, and in many ways, what's quite interesting is the revenues approach, and you could see that them lining up these cases, starting with Krista Ackroyd in 2018, which was, in my view, had the facts most extreme and most in HMRC's favour. So it's not surprising to me that that case was the one which happened to find its way before the tribunal first. But the argument that the revenue have been running and almost pushing far beyond the relevant, I think they've been pushing it far too far, is the question as to whether or not control, which is one of the things you need to have an employment relationship. They've been putting an awful lot of emphasis on the concept of editorial control. And they say that if the presenter is under the editorial control of the broadcaster, then the revenue can tick the box, we have got control. That's certainly how they're running Krista Ackroyd in the first tier tribunal. But I thought the upper tribunal seemed to say it was less important. I think it's less important. If you look at the Albertel case, the case involving Lorraine Kelly, the first tier tribunal actually held that editorial control was held by the ITV. But even so, that was not enough to tick the control box. So, and I think that's the test, because if you go back to the ready-mix concrete case, going back to 1967, 68, which is almost the starting point in all these cases, the judge there, Mr. Justice Cook, said, also Mr. Justice McKenna, said that control looks at the how, what, where, and when.
During the performance of the services.
Exactly. And what we've seen more recently is that the most important aspect of control is the what. And the revenue will say, well, if you are under our editorial control, it means we can tell you what to do. But what the judge in Kickabout said is that editorial control is more the how. How do you perform your job? The what is, what are you being asked to do? What is the task you're being asked to perform? And in Kickabout, it is to present this show. In Albertel, it was to present this show.
Absolutely. Yeah,
and there was a very good line in the Kickabout decision, which made it fairly clear as to how they saw it. If I can find the actual line. Yeah. In our view, a right to direct that a broad category of service be performed under hypothetical contract is more indicative of a master-servant relationship. That's the old terminology for an employment relationship. While the narrower the services which may be required, the more likely it is that the contract is for services. In other words, you're providing your services as a self-employed individual. As old authorities might have expressed it, can an individual who is engaged as a gardener be required under the contract to paint the owner's house? And that was precisely the same point I made in an article I wrote immediately after the Chris Ackroyd case first came out. And in Albertel, in Kickabout, the presenter was asked to present a show. That's the what.
Absolutely.
But that's something that is contractually obligated. Once you've been asked to do it and you've agreed to do it, you have to do it. But the what, in order to make it enough control, as far as I'm concerned, what you need to do is to have the presenter being asked, well, you can present the weather, we can get you to do other presenting jobs, not just this particular.
Yeah. I mean, the way I sort of see this what on control is that if you don't know what you're doing before you turn up, then they've probably got control over the what. Whereas if you've agreed in advance, you're going to do I always talk about sheds for some reason. So if you're going to go and build a shed for somebody, you're just building a shed. That's it. You know what you're about to do, and you build the shed and you go. But if you turn up to do handiwork you don't know, and you're told in the morning you're building a shed, and in the afternoon a rabbit hutch, and you come in day 2 and I don't know, I'm running out of things to build, but you don't know. You're asked to come in. I guess in the presenter's case it would be you're asked to come in and do broadcasting about news, as opposed to how about this football show, or I'm not sure how you describe like Lorraine Kelly's show. You're the expert on Lorraine Kelly, but entertainment is it's defined, isn't it? It's you can't do anything out of the sphere of what's originally been agreed.
Absolutely, and if you look at the contract in the Krista Ackroyd case, this is where there was that subtle, but I say fundamental difference between her contract and the other contracts in these other cases I've been looking at, because what she signed up to do was on roughly 200 days a year to provide her services to the BBC for whatever the BBC might require for its general output. So whilst there might have been the understanding that she would be presenting her services on Look North, the contract actually said they could get her to do the weather or to present Strictly. In other words, they could get her to turn up and, as you said, paint a shed or do another show. Whereas all the other contracts I've seen are much more focused on, you are presenting this show.
Absolutely.
That's the job you've been engaged to
yeah.
provide.
I mean, I do know some more details about Ackroyd's case. And I mean, from what I've seen, I get the impression that she thought damn well that she was being poached from. Was she doing ITV before? I think, wasn't she?
It was on one of the commercial channels. Yes.
But she was poached because she was very good at what she did. She organised the Look East programme. She was brought in to do that show and bring Look North. That's it, and increase all the ratings and so on. And she did, and she was very successful at it.
Yes.
Now, her contract didn't say that that's what she was brought in to do. It was just one of these. Oh, just sign here, and you know, and it was one of these sort of boilerplate contracts, and we're seeing these a lot in the media industry, and there's still lots of presenters that are under review, and it's a warning, isn't it, really, for don't just sign any old contract and then expect to rely upon what's actually happening in reality, because that comes secondary to the express terms.
Absolutely. Although I would say that it would be very difficult for any presenter, however eminent they are, to persuade BBC, ITV, Channel 4, or whichever company is making the programme, to say that the broadcaster doesn't have editorial control. So there'll be certain elements of control which will ultimately be in the hands of the broadcaster and not the presenter. But nevertheless, where Lorraine Kelly was very successful, and to a limited extent Paul Hawksby was, is that they had pretty much control as to the layout of the programme on a particular day. They had that day-to-day control. So ultimately that's not enough, but it did help the picture that they were the ones who were guiding the show. And again, it's where the newsreaders don't have so much autonomy in how they present the show, because there are too many external factors, and within the BBC itself, telling them what to say and how to say it. So, but I think one of the interesting things that I picked up from the Kickabout case, and I don't know whether it's something which will be considered in this hearing this week, is that when reading the decision, they did not seem to sort of make a finding on control or on mutuality of obligations on some of these irreducible minima of an employment contract. What they did is they expressed, it was a judge in particular, the one with the casting vote, who was expressing views as to how persuasive they were toward the ultimate picture. And effectively, they were going down the route of painting the picture, which is what we did in Paul and Lama. Whereas I've always understood that what you have to do is you have to show that there was the mutuality of obligations sufficient to make it an employment contract. You have to have control over the presenter sufficient to make it an employment contract. Then you have to look at the overall picture as well. But nevertheless, one has to look at the question of mutuality of obligations, control. Personal service isn't relevant in these cases because that was always accepted. And look at those in isolation and not sort of give a nebulous answer, well, you've got some elements of control. But that's something which no doubt the Upper Tribunal will be looking at, because I think there are questions as to how the first tier tribunal approached it, which will certainly make it ripe for review by the Upper Tribunal, although I don't think that the ultimate decision of the first tier tribunal is wrong.
It's a difficult one, isn't it, for people looking at these cases? Because on the surface of it, this chap had been delivering this same show for 18 years.
Yes.
He was allowed to. No, he was contractually obliged to deliver 222 programs. I think it was a year, or was it over the 2-year contract? But there was a minimum number of shows of the show. I think it was the show a year. And the sort of bit that didn't quite get them over the line entirely for mutuality of obligation was that at any point, TalkSport could just say, oh, you know, the 222, yeah, actually, we don't need to do anything for a month and you won't get paid. Now, that takes us into the area of casual work, doesn't it? You're only getting paid for work done.
It does. And I expect HMRC to come in heavily on this point, because ultimately It was a question of how do you interpret the contractual relationship? And that is a question of law. So whilst the first tier tribunal is the final arbiter on questions of fact, the upper tribunal will have every right to re-examine that conclusion as to whether or not Mr. Hawksby would be always entitled to a minimum of 220 payment for 222 shows, or whether it is a pay-as-you-go approach. And that the upper tribunal might say, actually, when reviewing the contract, we can see why the first tier tribunal reached this decision because it's all terms in minimum commitment. But ultimately, we say that Mr. Hawksby or Kickabout Productions Limited was always entitled to a minimum payment as well. Having said that, that might tip the balance as far as mutuality of obligations is concerned in that overall picture. But ultimately, as I said, I think the first tier reached the right decision, even if I have a few questions as to how it got there.
I would certainly agree on that mutuality of obligation point, that there just appears to be some clauses in the contract that were drawn attention to in the decision, which were almost like a get out, saying, you know, oh, this is going to happen, minimum number of shows, minimum's this, and you have to do this. And except that, oh, by the way, we'll just put this clause in that says you don't have to. And if you look at the whole picture there, you think, well, really? But then you think, well, you could have firms that decide to then use that approach as a way to try and keep contractors outside IR35, which may be valid in many circumstances, but in others it wouldn't be, and it would be considered a sham. In this instance, I don't think it was a sham, because if his ratings absolutely tanked, then they needed to get rid of him.
But then the question is whether or not they're signed up to a 2-year commitment, and if the ratings fall down, they'll know after 6 months, but they'll either have to carry on for 18 months or reach an agreement. And commercially, they might say, look, we'll pay you for 6 more months, but we'll end the contract early. So they will get something better than, they will get something they're slightly happier with. But as you said, you can't have sham terms in an agreement. And so whatever you put in the agreement has to reflect the reality of the terms, the relationship between you and and the client. But if I go back to something you said before, you mentioned the fact that Paul Hawksby had been presenting this show for 18 years. And that's a point which the Revenue will no doubt highlight, and they were almost trying to make the same point in Albertel. You've been doing this day in, day out for a number of years. But I think the Revenue is at risk of pushing that point too far. And if I just use an example, let's say the club down the road decides to get me to do 6 gigs on a Sunday night at a comedy stand-up, me comparing. They don't, and they'd probably be wise not to. But I don't think anyone would suggest that that relationship was anything other than a self-employment relationship. But let's say, and we are getting into the realms of hypothetical scenarios, I'm so good at it, they get me to do another 6 weeks, and another 6 weeks, and another 6 weeks.
Yeah.
And each time it's only for 6 weeks, or maybe they say, look, actually, you're doing so well, we'll give you 3 months, 6 months. But at the end of the day, I can find myself having done it for 15 years, almost every Sunday night. But just because I've been doing it for a long time doesn't make me all of a sudden an employee, because the entire relationship is one of self-employment. I've been writing, to use a personal example, I've been writing for Tax Advisor, and I've had an article in Tax Advisor for every month for over 15 years. But there is no doubt that I'm providing those services in a self-employed capacity, even if it's become a regular slot.
Would they perhaps try and use one of HMRC's arguments and say that it's crystallized into some sort of legal obligation for you to do that article every month? I often see that argument.
Well, I think it would be very hard for anyone, either me to say, I expect to be able to write an article, you must pay me for the article you haven't published because I expected you to publish it because of what's happened over the last 15 years, it's quite clear that there is no commitment one way or the other. And if I decide, actually, July 2020, I don't fancy writing an article because of lockdown, or I just fancy a day off, a month off. They can't force me.
These whole arguments about lengths of contracts are very difficult. And you see everyone sort of try them on a bit in court, and everyone shakes their heads and agrees that, okay, it's got nothing to do with it, but it might imply other things, shows other things, but on its own, it's not enough. I mean, going back to the first tier decision, the judges said, it was in paragraph 20, in our view, increased clarity is badly needed. And it does seem with all these presenter cases, that's very, very true. I mean, the classic contractor cases, we've had so much case law on it, and they seem actually pretty simple. I mean, well established, but there's so many nuances in the broadcasting industry. Do you think we'll get clarity from this particular case?
We might get a bit more clarity on mutuality of obligations, in that it's going to be a clear part of this case, and I think it's something which will complement the Professional Game Match Officials Limited case we had a few weeks ago. But I think what would also be very helpful is for the Upper Tribunal to make it clear as to whether or not, when looking at mutuality of obligations, looking at control, is it a case of a binary question, is there sufficient control, etc., or is it still just part of the overall picture? Because I don't think it is, and I think that would be a clear departure from what was said in ready-mix concrete.
One area of the Kickabout case, and it seems to be an argument in all of the cases, is, and I don't get this, it doesn't seem to make sense, is that HMRC will argue that because there are these rules by Ofcom that say you can only work in a certain way and there's guidelines and things, then it means that you're controlled. That doesn't seem to make sense.
Yes, I'm a member of the bar. I'm governed by the Bar Code of Conduct, and someone engaging me might specifically require me to abide by the Bar Code of Conduct. I have to do it anyway. That doesn't make me an employee or under someone's control. It just explains the environment in which I'm providing my services. And the football referee's case, it was the first tier tribunal where it came up. It was almost, the argument from the revenue was along the lines of, well, these individuals who are acting as referees are clearly under the control of the FA, etc., because they don't choose how long the game should last or where penalties should be taken from.
Now, I know enough about football to know that there's a phrase, I am the referee, you know, I have the final say.
But the point is, they don't.
The idea of them being controlled is silly.
There are certain things that they have to abide by. And it'd be quite interesting to see what would happen if a referee says, look, forget the penalty being taken from 12 yards out, let's decide it should be taken from the corner. Yes, there'd be a complete riot on the field, but it's just not a situation that's ever going to arise. The referee has to follow the rules of the game. And presenters themselves have to abide by Ofcom, and the broadcasters are also licensed by Ofcom. They have to ensure that people abide by the Ofcom rules. It's at the most it relates to editorial control, but ultimately, as far as I'm concerned, in most of these cases, there isn't sufficient control to make someone employer or employee, because all they've been all that's happened is they've been contracted to provide a particular service. What's the gig? What's the job? And everything else is just commentary.
It does seem that they're certainly up against it with lots of these cases.
One thing, Dave, which I think, if I can just intervene here, which is going to come up in the Kickabout, and certainly something where will be relevant, is a point at which the judge and the member did disagree. And this is the relevance of statutory payments. Because what is typical in all these contracts is that the presenter has a fee they can expect to receive over the course of the year. Obviously, depends whether it's a minimum payment or not. But and they're asked to provide to services and commit themselves to a number of days in the year. Now, that in itself has inbuilt some form of holiday pay, because you're not presenting 52 weeks of the year, you're presenting 46 weeks of the year.
Absolutely.
Number is. And but you're given a fee. Now, there is no express provision for holiday pay. There's no provision for pension contributions. There's no provision for statutory sick pay. And in many of these contracts, if you're offered more than a number of days, they can actually terminate the contract, which to me is a pointer against employment relationship. But let me just focus on the statutory pay. The Revenue run the argument saying that this is not an employment contract. This is a contract between a company and a broadcaster. However, if you were really an employee, then whether or not it was in the contract or not, statute would impose those terms on the employer.
Yeah.
Therefore, the absence of any such term from the contract is a neutral point, because at the end of the day, it doesn't make you an employee or not. And that was accepted in the Christa Ackroyd case in the first tier tribunal. It didn't seem to be picked up in the upper tribunal, but it was rejected in Athol, and it was rejected in Kickabout by the judge, but not by the member in his dissenting decision. And I can see the strengths of both arguments. I think at a very minimum, the absence of those terms are a pointer to intentions being not of an employment relationship.
Yep.
And I think I could take it even one stage further and say this is all part of the overall picture, because this is a picture where you're being paid a fee for a service. So it's a service which you might repeat over a number of days, over a number of weeks in the course of the year. But it's certainly part of the picture. But it'd be interesting to see whether the upper tribunal grapples with that. I suspect they will, and will give us some quite clear guidance as to whether or not it is a relevant pointer away from employment or whether it's completely neutral. And I'd be interested to see how the upper tribunal deals with it.
Yeah, so I mean, the sort of general feeling, well, when we tend to deal with cases is that, well, if you're giving people holiday pay or sick pay, then that's a huge pointer to employment. But
Yes.
If it's not there, then it's pretty much neutral. But the last thing you want to be doing is paying people for not working and being sick. That's what you do with employees. But it would be interesting to see how they cope with this in Kickabout, because as you say, it's featured quite a lot in the decision, which was surprising.
Possibly because it was where the two parties differed.
So just to recap, the bits that we think that we're interested in seeing over the next few days: mutuality of obligation.
Yes.
Yeah. The areas of control, particularly around editorial control.
Absolutely. Also, whether or not those are tick box exercises in which you have to tick that those exist, or whether they're just merely part of the overall picture.
Okay. So,
and then there's the statutory payment situation.
The statutory payment situation. So what the plan is for Keith and I, having had this discussion, is we're both going to watch the case, and then we will, if we have any viewers left, we will have another discussion about what we think happened in the case, and if it provided any of the clarity that lots of people are asking for.
Yes. Well, we'll both look forward to watching the case as it goes ahead in the next couple of days.
It's been an interesting discussion, Keith.
Thanks very much.
Thanks,
Bye.
Keith.